ladies and gentlemen. This is the June 29, 2021 meeting of the Board of Adjustment. The first item is to call the roll, please.
Mr. Duchamp.
Here.
Mr. Stewart.
Yes.
Mr. Deek.
Here.
You have a quorum.
Thank you. I should also note that both Barbara Jones and Jennifer Fassner here, and as is our trustee, attorney Dennis Wheeler. Let us first look at the agenda before we go any further and see if there are any additions, deletions, corrections to be made to the agenda of today's meeting. Mr. Deek?
Nope, nothing here.
Mr. Stewart?
No change.
And I have no changes either, so the agenda is approved. Now, before we go any further, there is the allegation that there were notice deficiencies there. And I must tell you, as board chair, I saw it this morning that there is this allegation that was made. And so I have not had any opportunity to review it, and I don't know about my cohorts here on the board. But let us hear from the clerk first. Was this advertised in the usual manner, Madam Clerk?
Yes, Mr. Chair. I can go into.
Are there any deficiencies of the notice that you are aware of? There is the allegation by Joan Priestley that it was not advertised properly and that it violates the open meeting law. Are you aware of anything of that sort?
No, Mr. Chair. If it pleases the board, we have a statement about how this meeting was publicly noticed.
If you would read that, please, or address that issue, please.
Be happy to. The clerk's office posts notice of Board of Adjustment meetings on the Municipal Boards and Commissions calendar and public notices page of the municipal website. The charter at 1713H provides that the definition of publish is to cause to be posted on a municipal website designated for public notices, the matter required by law to be published. Unless otherwise provided by the Assembly, posting shall be maintained for 7 consecutive days. The Assembly shall provide for additional modes of dissemination. Some of the additional requirements of the Assembly are that notices are required to be posted 48 hours in advance. In this case, the public notice was placed on the public notices page required by the charter on June 16th, far more than 48 hours in advance. Then the BOA webpage was updated on Sunday, but it also has a static link to the boards and commissions calendar that included the public meeting date. In addition, on June 16th, the clerk's office sent an Outlook calendar invite to board members and the appellants and appellees in cases 2020-2 and 2020-3. The clerk's office is not like a court which posts all motions, orders, etc. online, and the clerk's office is not required nor equipped to do this. As a courtesy, we post appeals and final finding conclusions to appeals as time and staffing allows, but this is almost always done as a look back in time on a case, not as the case proceeds. Orders and motions are served on appellants and appellees by the other party, and the clerk's office serves Board of Adjustment orders on appellants and appellees. This was timely done in these 2 cases. There is no requirement in the code or charter for agendas to be posted online. However, the code does require a written posting in the public notices page to include the date, time, place, and subject of the meeting. The public notice included the title of this meeting, Assembly Board of Adjustment meeting, regarding motion for reconsideration on Appeal 2020-2 and 2020-3. It is descriptive enough for the public to ascertain from the notice what the board will be doing at the meeting. And the code citation on that is 1.25.015, Notice of Meeting Definitions.
So in summary, are you satisfied that the open meeting requirements were met in this case?
We are.
Thank you. I don't see a microphone for us. Is this sufficient to pick us up?
This recording should
It used to
pick
be
you up.
that we used to wear something. Is this old-fashioned and no longer necessary? Good. All right. Is there any question that board members have for the clerk regarding the open meeting notice and provisions? Mr. Stewart?
No. No, I did look at one of the, it was a table that talked about public notice. And I don't see any conflict with that.
Okay. Mr. D?
I do not have any comments on this. I'm satisfied with what I heard.
Thank you. Like my two cohorts here, I'm satisfied with what was done by the clerk's office, and we will simply proceed. So the first item on the agenda is that we need to approve minutes of the meeting of May 11, 2021, and we were provided with a draft of that. Have we had an opportunity to review that?
Yes, Mr. Chair. Yes.
Mr. Stewart? If you had an opportunity to review them?
I looked it over and on its face, I don't see anything right now.
Okay. I have reviewed it myself and I don't see any deficiency unless I hear any objection, the minutes are approved.
No
Any objections? No. Mr. Stewart, any objections to the minutes?
No.
Neither do I have any, so the minutes of the meeting of May 11, 2021 are approved. There is no old business to come before us that I'm aware of. Mr. Deek, are you aware of any old business that we need to discuss before we get to today's subject matter?
No new old business. We're working on the current one, so.
All right. Mr. Stewart, any old business that you're aware of that we need to address before we get to today's?
Do we need to address any possible conflict of interest on the record?
I don't think we need to, unless you need to amend your previous statement that you have made.
I just wanted to make sure it was on
Any
the record.
conflict of interest that we are aware of, Mr. Deek?
No conflict of interest.
Mr. Stewart, you don't have anything? Neither do I. All right, we then proceed to new business, and what brings us here today is the applicant, I should say, the applicant Holtquist's motion for reconsideration of the order entered by this board on May the 12th, 2021. There have been at least two oppositions filed to it, one by Joan Priestley and one by Sean Domogowski. And I think we are ready to proceed with discussing that motion. Let's make sure that we are on the record. We are. Good. All right. In reviewing this motion before us today, I think the easy way to proceed and the orderly way to proceed here is to determine whether we should reconsider our order of May 12th and proceed from there. I will, unless I hear otherwise, I will simply make that motion myself and invite one of my cohorts here on the board to second that motion.
I second that.
Okay. I am moving to reconsider this board's order of May 12, 2012. May I have a second, please? Was
It was-
Were you
yes,
going
I-
to second that?
I did, yes.
Okay, all right. Well, let me speak to this motion. This case has a confusing procedural history, and part of the issue, of course, is that only the applicant, Holtquist, is represented by counsel. Other parties who are involved in this matter are not represented by counsel, and so we need to take that into consideration. At our previous meetings, when we discussed this matter substantively, we attempted and made an effort to provide clarity and give all parties a baseline from which to proceed. By the order of May 12, we provided that initial appeals were moot in light of the fact that the planning board had substantively reconsidered its original decision of June 3, 2020. We provided for commencement of appeal rights under AMC 2103-050 little c, and just for good measure, we provided that our decision of May 12 was interlocutory in nature. Now, that's a legal term that lawyers are familiar with. It simply means it is a decision that is given provisionally during the course of the proceedings. No appeal rights flow from that decision right then and there. Now, the applicant Hultquist wants us to reverse course and hold that rather than AMC 2103-050A5 little c, which we held applied, we should instead hold that AMC 2103-A4 applied. What it comes down to is what the term decision means in 2103-050A5C. Does it mean simply to the decision to rehear the case, as applicant Hultquist wants us to hold, or does it mean the decision after the rehearing of the case has occurred, which is what we did and what we decided? I am of the view that in looking at this, why would the code provide for a separate appeal of the planning board's decision to rehear the case, as urged by Hultquist, rather than speed up the decision-making process, which is what Hultquist wants and what we are kind of held to uphold as well. It would in fact delay it. The party aggrieved by that decision only could first appeal it, and then, if it lost, await the substantive rehearing decision and appeal once more. This seems illogical and not in the best interest of the process of speedy adjudication of a case. In other words, having two appeals, two appeal opportunities, is not what I contend the code had in mind. The fact that there is an argument over what code section applies to a decision after reconsideration shows that there is a lack of clarity in the code. To penalize a party in interest by adopting one view over another, with the result that an appeal time is shortened for some parties, the appellants in this case, but not to the others, that is, the applicant, would be inequitable and not balance the interests of the parties in what is clearly a highly controversial case that is likely to proceed far beyond any decision that this board will make now or in the future. By denying the motion for reconsideration, we would leave matters as they are for the time being, allowing any aggrieved party, presumably applicant Hultquist, the right to appeal all matters in the case, including our decision that gave rise to this motion for reconsideration, at the conclusion of the appeal process before this board. Therefore, I will vote to deny the motion that I made, and I invite comments by my cohorts. Mr. Deep.
Yes, I guess that's the burden if you second the motion, but I will go second. This is this definitely is a case which has been fraught with application of the standards of the code in a consistent manner about definitions and the procedures. It's not a, it's unfortunately I'm more of a land use expert than a code expert in that regard, but I can state that that was obviously a procedural process which we had to address in the previous meeting in May 11th, and then the order followed on May 12th. And that order's intent was to clarify the process and allow an equitable basis for all parties to move forward on the original case. And just as you stated, to be equitable for all parties, I believe that it is the correct answer, correct course of action to deny this motion and allow that process to take place and take its course. We don't want to predict how that will go. Maybe it is viewed as unfair or perhaps not in the best interest of the applicant, but also it is in the best interest of the appellees to be able to respond to the original case, state their intent in terms of addressing the issues of the original case, and then if they choose to do so, then this process moves forward. So that is why, in a procedural basis, I'm in support of well, I'm not in support. I'm against the motion. I would vote against the motion, and that is the reason why.
Okay, thank you, Mr. Deep. Mr. Stewart.
One of the things that I looked at when we first started addressing this is where is the due process for excuse me, for people other than the applicant, and the due process I saw was not within the bounds of what we were seeing in the regulation or in code. So I think what we came up with is an equitable way to ensure that due process is in that code. And with that in mind, I would like to see that stay where it's at, and then let the rest of the process go forward to see what happens, because there's a lot of things that could happen in this particular case, many things. So I intend to vote against the motion for reconsideration.
Before we vote, I want to be sure that it is clearly understood that if we rule against the motion that I made, this is not the end for the applicant Holtquist. We were very careful to provide in our order of May 12th that it was not a final appealable decision. If we deny the motion for reconsideration today, that order of May 12th will stay as it is. And that means that upon the conclusion of the appeal procedure here before this board, any party aggrieved, and that includes applicant Holtquist, can appeal the matter to the Superior Court. In other words, what we rule, and can raise the arguments again that have been made in this motion for reconsideration. In other words, it's simply a provisional ruling that we entered on May 12th. And as my cohorts on the board have stated, and I agree with that, we provided for an orderly appeal process and provided for some guidance to the parties. Whether we were correct or not is not up to us, I believe, to determine at this point. We simply let the appeal process that we established go forward and let the chips fall where they may. So having said that, is there any additional comment before that either one of my fellow board members wish to make before we vote on the matter? Mr. Deek.
Just one comment, and that is, it is, again, being a land use expert who likes to get things done, this is highly unfortunate that this case ended up this way. I would encourage there's actually a planning director's note here, but I encourage our planning department to also look at this kind of cases so the definitions are clear, the processes are clear, and we don't deal with process instead of content when we get into land use projects. I consider that highly unfortunate that any developer has to get into a process-driven dialogue versus a content-driven dialogue, but I think it's the right decision to allow the appeal process to take place and have a baseline to start from, And I think that's what we did decide to do, and that's why I will vote against it.
Okay. Mr. Stewart, any additional comment?
I have no further comments.
Okay, the only comment I wish to make is that when we look at the timeline in this, it is really unfortunate that we are now where we are, because the first decision by the board of, planning
Planning
board
board.
in this case, was done June 20, 2020. That's over a year ago. And we still do not have a decision, a final decision on the plat, because it's now subject to appeal. So I think by voting to deny the motion, as I think we will, we are trying to speed things up here so that the applicant, Holtquist, can come up with a final decision that is either appealable to Superior Court or to which they can agree to and just move forward. So, with that in mind, Madam Clerk, would you please call the roll?
Yes, the motion to reconsider the board's order of May 12, 2021. Mr. Buchap?
No.
Mr. Stewart?
No.
Mr. D?
No.
Motion fails.
And the motion fails by a vote of 3-0 or 0-3, whichever we may want to look at it. And it appears to me that that is the end of the motion for reconsideration. The motion has been denied, and it appears that we will simply let the appeal process take its course. Any further comments by board members regarding this matter before we move on with the agenda? Mr. Stewart?
No.
Anything further? Mr. Deacon?
No, nothing further.
Nothing further, and I have nothing further. We then proceed to member comments. Any member comments you wish to make, not specifically regarding this case perhaps, but other matters for the board?
No comment.
Mr. Deacon? No. Mr. Stewart? No.
No.
And I have nothing either. Audience participation. Please note, audience participation may not concern adjudicatory matters before the board pursuant to AMC 2103-050810B. The Board of Adjustment shall not hear argument nor take additional testimony or other evidence. Board of Adjustment may consider only the material contained in the appeal packet. Having said that, is there any comment by the audience that you wish to make that does not concern this particular case that we just considered? Anything?
Sunny out.
I'm sorry.
What else was I to say?
Do you wish to go on record and make some comments? If so, please state your name, please.
My name is Dave Alquist. I don't want to make any comments because you don't allow me to. So,
Okay, all right. Anything further? If not, I will entertain a motion to adjourn.
So moved.
Do we have anything else on the agenda that we need to set up a date for?
No, we do not.
Okay.
So do you have anything further before we adjourn? No? And I think Mr. Deek has made a motion
I
to
did.
adjourn,
Also.
and Mr. Stewart is seconding that. And is there any argument over adjournment? Seeing none, it is approved by a vote of 3-0. Unanimously, I should say. All right, there we are.